Oh, we have one, we have a couple of them. Okay, all rise.
The universe may have been frozen out now.
All right, please be seated. Italian lunch today, right? Very good. Okay, Ms. Perez.
Afternoon, folks. Afternoon.
Hello.
Okay.
Yeah, the photograph.
Oh, thank you, Your Honor. I was just going to ask. It doesn't show too well up there, but we'll do the best we can.
Can you focus it down?
To change that, there's a screen that says menu. You hit the menu and it'll tell you how to
Okay. All right. Can you see that, Ms. Evans?
Yes, sir.
Ma'am, can you tell me what's in that picture?
Yes, this is a photograph depicting the cleared space on the floor in the dorm room. We have, myself, I put down evidence marking stickers to designate certain areas that were swabbed and the certain areas around those stickers that were swabbed for potential trace or biological type evidence.
Okay, did you photograph the floor before that, or?
I did not take any photographs of the scene. Investigator Tilly was responsible for that.
Did you place those little placards there?
Yes, I did.
Your Honor, if I may introduce that in next in line, please.
All right, that would be number 29.
I'm going to show you two pictures, ma'am. Have you seen those before?
These are photographs of the dorm room floor.
Okay. Looking at the first one on top, so they're crime scene photographs from room 213?
I believe these are, I'm not sure if these were included in our crime scene photos or after, but I recognize the area.
Okay. So you don't know if they were done before or after?
These would have been done, if Investigator Tilly took these photographs, they would have been taken prior to the stickers being placed on the floor.
But you were with her, correct?
When
you arrived, you indicated Ms. Tilly was outside the door, and then you guys went in and processed the crime scene together, correct?
Yes, she had begun photographing the interior of the scene prior to my arrival.
I just showed you that picture, is that correct?
Yes, sir.
Okay. In that photograph, there seems to be something in the middle of the floor.
Are you referring to the
A little white piece of paper.
Yes, sir.
Did you process that?
I'm not sure what that piece of paper is, so no.
The photo I showed you previous to this, it was not marked. Is there any reason why?
I'm not sure what that, I can't tell what that is from the photograph.
Okay. Well, I'm going to go back and show you I'm going to show you Exhibit 29. Do you see it on any of those placards there that you marked?
No, sir.
I'm going to show you the second photograph of the two that I showed you. Do you see another, or the same, I don't know, piece of paper there?
I see what you're referring to, yes.
Okay. When you place the placard, do you see it there?
No, sir.
I'd like to move those two in the next in the evidence, Your Honor, please.
Okay, that would be number 30.
The purposes of gloves and booties that you wear when you process a crime scene is what?
To limit any potential contamination from us into the scene itself.
Also, if you pick up a piece of evidence, that your fingerprints don't get on something, correct?
Correct.
Is it unusual for someone processing a crime scene not to use gloves and pick up evidence?
Unusual?
Yes.
I mean, depending on the type of scene, we primarily would wear gloves when processing for latent prints specifically.
You wouldn't pick it up without a glove, correct? A piece of evidence?
I pick up evidence every day without a glove in my current unit, in my current position, so it's dependent upon the type of scene and type of evidence that you're dealing with.
Now back to the photographs. The ones I just showed you, you didn't see any date or timestamp on those, correct?
I don't believe so.
You want to see them again?
Sure. There may have been. I don't recall.
I don't need them published. You can just show her.
No, I don't see any date or timestamps.
So as you look at them right now, you wouldn't know the date or time that you took those.
Looking at these, no, I would not, but we have that information available if it's needed.
All right. I'm going to show you. I think it's a 4-page document. Are you familiar with that document?
Yes, sir, I am.
Okay, and what is that?
This is a printout listing the number of photographs that were taken at a scene, as well as the image numbers that correspond with those photographs taken at the scene.
Okay. So could you tell me, looking at that and the pictures that you just saw, the 3 photos, where those pictures are?
No, sir, I cannot.
I'm going to publish this here. Now, you indicated earlier this morning that they come out in chronological order. Is that fair to say?
Yes, sir.
Okay. And you also said that this cannot be manipulated. Is that correct?
Once they're downloaded, we cannot manipulate them. Correct.
So I'm going to show you page 1 of the 4-page document I showed you.
Because it's too small to read.
Go ahead. Okay. Is that a little better, Your Honor?
Yes, it's better.
Okay. Now, I'm going to show you the top picture. If you go from, it says officer up top, and then you go down, it says F, and there's a colon and some information. Do you see that, ma'am?
Yes, sir.
All right. And if you follow it, after IMG, it says 2965. Are you familiar with that?
Yes, sir.
Do you see that?
Yes, sir.
Okay. Is that the picture number or sequence number?
I'm not sure what that is referring to as far as the Canon software goes.
Okay. Now, If you go, let's skip the next one, D, and I'll take you down. It says 2966, 2967, 2968. You see how that goes?
Yes, sir.
Now, if you go back up to the second one, it says 3046. Does that seem to be out of sequence?
If that is the sequence of photographs, then yes, that would have been downloaded out of sequence.
Well, I'm going to show you the last page of the 4-page document I just showed you. And if you go over, you see where it says, the last picture on here says 3045. You see that?
Yes, sir.
So the one that's now in the second position, which is 3046, would appear that it's been moved from the last position. Would you agree with that?
Yes, that would have been moved if it was moved prior to the photographs being downloaded.
Do you know what that picture is?
Off the top of my head, I believe it was a photograph of a consent form.
So, if that was the last picture taken, and now it's moved up to the top, that would appear that someone gave consent before the pictures were taken instead of after the pictures were taken. Would you agree with that?
No, I would just agree that a photograph was moved out of the order that it was taken to the top to show that particular photograph in the order that it was shown.
And this is after you said it can't be manipulated, correct?
Once we download the photographs, we cannot manipulate them, no.
Okay. It's my understanding that you did not process one bed in there. Is that correct?
That is correct.
In your panel scan that you showed, are we able to play that? No, it can't show. Okay. In the panel scan that you showed, it appears that the top bunk has been stripped of all this bedding.
Well, do we have actual photographs of that, of the top bunk in the room? That series of 11 photographs, I don't know if any of those show that, but I think it would be better to let her see it.
Because our computers don't have the software to play that, Your Honor.
Okay.
Mayor, I'm happy to pull up the pan-scan image. It's just
Well, that'd be wonderful. Thank you.
Okay, we can't see it.
There's one
But
where you can see it in the background, but it's not a full.
yeah, Joan Norman, if you could pull that up, because for her to testify to something she can't see, it's not.
I completely agree, Your Honor, and we had two people trying to work on it.
Well, Joan Norman said she would pull it up. Okay. It's on the small.
Oh, I'm sorry, Your Honor, I'll go over here. So, ma'am, showing you the bottom bunk and the top bunk, you processed the bottom bunk with the ground sheet. Is that a fair statement?
Yes, sir, it's correct.
And on the top bunk, it looks like there's no bedding on there. Is that correct?
There's bedding present, yes, sir. Sheets,
Oh, there is?
pillows.
Okay. Is there a bedspread present?
I'm not sure if the white thing crumbled in the corner may or may not be a bedspread. I'm not sure.
And that's the way you found the room when you got there. Is that correct?
Yes, sir.
Thank you, Mr. Horn. Thank you, Your Honor, for that.
All right.
You located and processed vomit, is that correct?
We located what appeared to be vomitous material and collected that, yes, sir.
And that was on the floor and up by a barrel or a basket or something?
It was on kind of a plastic tub located off the left wall beside one of the desks.
I'm going to show you a picture. Since it's still funny. Do you remember that photograph?
Yes, sir.
Okay. Again, there's no date and time stamp on that, right?
That's correct.
Okay. And did you process that blue towel or green towel?
We looked at the towels with the use of an alternate light source and collected the towels.
Okay. And was there a presence of semen on that towel?
The light green towel fluoresced in an area near the border of the towel that was indicative of the potential presence of seminal fluid.
Did you process a Swifter, Swifter to clean the floor?
No, sir, I don't recall seeing one in the room.
If I may have that marked next in order. If this,
That would be number 31, I believe.
one more. I think that exhibit has been shown to you already?
Yes, sir.
Yeah, it's just a picture of, and that's the picture of the condom box, correct?
Yes, sir.
Now, when you got in there, was the drawer open?
When I arrived,
Correct.
when I did my walkthrough, the drawer was not open.
And who opened the drawer?
Myself, Investigator Tilley, or Detective Mayo.
Okay. Now, was Mr. Mayo wearing gloves at that time?
I don't recall.
That was, when was that picture taken? How many days after June 23rd?
We arrived on the 27th of June, so about 4 days after
4
the
days
incident.
later, okay. Did you process anything else other than the condom box and the condom wrapper in there?
Inside of the drawer, no, sir.
Bless you.
Bless you.
That box indicates how many condoms were in there?
The box states that 12 were located
And you found how
inside.
many inside?
6 inside.
Did you process those inside?
We did not.
And the single condom outside the box, you found no fingerprints, is that correct?
That's correct.
And you found 2 identifiable fingerprints on the box, is that correct?
Whether or not they're identifiable, I don't know.
You don't know.
I've collected
Okay.
2.
And where were they located on that box?
One was located on the front portion in the lower right-hand corner, and the second was located on the back side of the box in the lower area.
Do you know what finger?
No, sir, I do not.
Is that something you could tell during your crime scene investigation, what finger was left on the box?
I'm not trained to decipher that, no, sir.
I need, the photo, Randy's exhibit, 22, number 22. We're showing you Exhibit 22 that's already been published to the jury. Are you familiar with that picture?
No, I'm not.
So you did not take that picture, is that correct?
I did not take any photographs.
Okay. Do you know, you have any information, just yes or no, please, of who may have taken that photograph?
No, sir.
You indicated that one of the towels, I think a red and white one, or rust and white, I think, smelled like urine. Is that correct?
That's correct.
Did you process the urine for DNA?
We don't process urine for DNA. It was collected to be sent off to the state crime lab at the detective's discretion.
Do you know those results, just yes or no?
No, sir.
Were you looking, when you started processing the crime scene in room 213, were you informed that you were trying to identify individuals in that room?
No, we were not informed to try to identify individuals.
So when you were doing fingerprints, what was the purpose of doing that?
The purpose of that is to place an individual in a room.
Okay. So did you fingerprint any water bottles in the room that to identify any individuals?
No, we did not.
And you weren't asked to either, correct?
No, we were not. There were several water bottles and just various drink bottles, containers, items of trash thrown about the room.
And have you ever lifted a fingerprint off a water bottle?
I have, yes, sir.
Excuse me, Your Honor, I need to find this exhibit. I'll show you exhibit number 18B. It's been marked already. You've seen that?
No, sir.
Did you take that picture?
Again, I did not take any photographs.
Could you
pertaining to this
describe what's in
case.
that picture?
Objection, Your Honor.
Well, I think she can describe what she sees in there. She didn't take it, of course, but she can describe what she sees.
I see a hand holding a white watch.
Showing you 18B, so I close back to the jury. You described a white watch with a hand holding it, correct?
Yes, sir.
Do you see a glove on that hand?
No, I do not.
Thank you. Here I have some exhibits that Ms. Tilley gave me back. The 4-page police evidence processing, if the court could admit that, please.
All right. That would be number 32.
Honor, a photograph of the condom box with the condom process. I don't know if we have one in there.
Yeah, that was already
In there. Okay. Can we have a moment, Your Honor?
okay.
I have no further questions, Your Honor. Thank you.
All right, read the rest.
I should briefly have a reflect. Might need 1 second.
All right.
Ms. Evans, in your experience as a crime scene technician, could you describe the process that you would go through if you were to take photographs at the crime scene, and then kind of what would happen to them at that point?
When taking photographs at the scene, we start kind of big to small. You take overall views of what you're looking at to kind of set the location and the type of scene, and then you move in closer and closer and show locations of particular types of evidence or things of interest. That's done to document the scene and the condition that it is found before we alter it in any way. And by alter, I mean adding evidence markers and collecting certain items of evidence and taking that away from the scene. So we follow that order of documenting in the condition that it was found, and then we go back and place our evidence markers or the marker stickers on the floor and then photograph.
And does that whole process sometimes happen over several hours, depending on the scene?
Absolutely.
And after you've taken the photographs, what's the process that you would go through once you're done, so that they end up going back to the detective and becoming part of the case file?
Once the photographs are complete and we're finished with the crime scene, we return to our office where the photographs are downloaded onto a server so that they may be viewed by the detectives.
And when you download them, are you rearranging anything? Are you looking at the photographs? Are you kind of discarding ones where maybe there was a blurred image or anything of that nature?
When downloading, I don't do those types of things. I download anything that I take. In this instance, and I don't know because I did not download these, it looks like Investigator Tilley just moved one photograph of the signed consent form, if that is the photograph that they were talking to or referring about, to the top just for the flow of the sequence of the photographs.
So that is not something that would be completely uncommon if there was one image that didn't really go with the sequence of the others, or sequentially to put it at the front of the line.
Correct.
And Your Honor, I'm going to ask that a disc with all of the crime scene photos be entered into evidence, and we're actually creating that. The one we have has all of the ID officers' reports on it as well.
Okay.
But I would just ask that all of the photographs be entered as an exhibit.
Okay, that's fine.
And with permission, if we could have just 2 minutes so I can complete burning that disc.
Okay, and then you have other questions after that?
No, sir, I do not.
Okay, well, any recross of this witness?
Give me 1 second, Your Honor. We're discussing the new exhibit here.
Okay. By the way, who do you intend to call next?
Detective Chad Gish.
Okay, I think we're going to have a hearing on that matter. Okay. So once Ms. Evans is excused, I'm going to excuse the jury for a few minutes.
May I inquire, Your Honor?
Yes.
Thank you. Ms. Evans, Ms. Norman just asked you about all crime scene photos. Did you take all these crime scene photos?
I did not take any crime scene photos for this case.
Have you viewed all the crime scene photos?
I viewed what Investigator Tilley took of the case, yes, sir.
But you don't know what they are? Would you know what, when Ms. Norman indicates that all crime scene photos, could you tell me exactly what everyone is?
What do you mean, just tell exactly from memory what everyone is? Or?
Well, yeah, have you gone through them to identify each one that she proposes to introduce to you, with you?
I've looked at the crime scene photos taken by Investigator Tilley beforehand, yes, sir.
And how many are there?
That was listed on the printout sheet or on her report, which
Do you know
states,
people?
offhand from memory, no, I do not know.
And then, consent really doesn't matter if someone cooperated. Is that a fair statement?
I don't know.
Okay. I have no further questions, Your Honor. I would just object to the introduction of all crime scene photos.
All right. On what basis?
On the basis of foundation.
Well, I think that Ms. Evans testified that she looked at all the photos.
I don't know. She didn't say she knew how many she looked at. I don't know how many Ms. Norman has introduced. She just said all crime scene photos. I don't think that's my job to document that.
Well, the state's response.
Your Honor, I'm more than happy to allow this witness to flip through the photographs to verify that these are the ones that she has reviewed and is aware of. Also happy to give him the number of the photographs that are on the disc that were provided with discovery and correspond with the report entered by defense counsel.
And I think the report listed, I believe, 70 photographs. I'm not certain, but I think.
Ms. Halstead, look, I'm sorry, I just closed my copy of
Look
the
at that
report.
full-page printout. How many
On the fourth
photographs?
page, it should have a total number. I believe it begins 1 through.
Your Honor, I would ask Ms. Norman to present it to Ms. Evans for identification.
She can pass it to Ms. Evans. To answer the court's question, it's 79 on the report, which is exactly what is downloading right now, is 79
I
images.
thought I saw the number 70 something somewhere.
Much better memory than myself. Ms. Evans, how many photographs are listed in the report that's taken as part of the scene?
Listed on this report, it has 79 photographs.
Your Honor, the state is asking to enter the 79 images. Again, if Your Honor requires, I can have Ms. Evans go back through them.
Well, I really don't think we really need to go back through all of them. The defense has seen each and every one. If there's,
If we could have a copy of that.
Sure you can.
So we can look at it this evening and see if they're already, I can check too.
Absolutely. All right. Any Anything further from Ms. Evans?
Not from the state.
No, Your Honor. All right, thank you, Ms. Evans. You're excused. All right, ladies and gentlemen, as I mentioned, that we were going to have you step out for a few minutes. I need to take up something with the lawyers. Be a little patient. All rise. You're excused. Be seated, please. All right, if you would bring Detective Gishin.
Please, before we start on this particular motion, can I have 2 minutes? Quick restroom break, please, Judge.
Sure.
2 minutes.
I mean, why would that keep you from that?
I got a cup, but
I would keep him from using the cup.
I appreciate that.
All right, you want being honest. 2 minutes, 2 to 3 minutes, recess.
Your handwriting, I'm sure it's much better than mine.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right.
Your Honor, may we address the court briefly prior to
Sure.
having Detective Gish testify? Your Honor, we received motions from defense counsel yesterday morning as testimony was starting. The motions, while they are styled as a motion in limine, the content of the motions are a motion to suppress evidence, which the rules require must be filed pre-trial. It's not permissive, it's that it must be filed pre-trial. Your Honor has heard multiple motions on these exact same issues previously, and Your Honor has ruled on those motions by defense counsel. And Your Honor's order is in place prior to the trial. On multiple pretrial status dates, we discussed that the trial images that Your Honor ordered were the images that would be admissible in trial, that was filed with court. There was a very specific listing, and defense counsel for Mr. Vandenburg, his 2 of his 3 attorneys, were provided with an additional copy of that listing. And again, this motion, it does not comport with the rules of criminal procedure. It violates Your Honor's order, and it is yet again defense counsel waiting until the last minute, but this isn't even the last minute. This is beyond the last minute, beyond the last hour, beyond the last day. This should have been done months ago, but the rules of criminal procedure prohibit it. It is not allowed. And the state would request that Your Honor deny the motion in its entirety, and if we need to address some of the specifics of evidence that Detective Gish will be testifying to, we can discuss things that might relate to hearsay or other technical matters. However, as it relates to the images, the video, anything of that nature, the state requests that the court not hear it. In addition, the memorandum of law filed by defense counsel that allegedly supports their request is not based on any case law that would allow Your Honor to grant the request. They are citing to a federal civil case which involves a motion for summary judgment for damages caused by lightning to a hole in an arbitration case, which has absolutely nothing to do with the law that would relate to the request of Your Honor. The second citation is a Mississippi College Law Review, 221 pages of a Mississippi College Law Review. The third citation is a 2012 internet posting of an article in which they state the author of the article's name. They state that it is a David, I think it's Cluley, when it is actually written by a Graham Cluley. Not only is it a 2012 internet article, but the article is about fake Facebook accounts, which again has absolutely no relevance to the evidence in this case, and it has no relevance to any law that would allow them to make this request of Your Honor. Not a single citation, which I do have to admit I finally stopped when I got to that point, references a criminal case where there is an expert witness in computer forensic analysis and mobile device analysis that is testifying about a forensic analysis of an electronic device. And again, it is precluded by the rules of criminal procedure for any of the images or videos that they have requested not be admitted in this trial, but the remainder of this motion is not based on law.
All right.
Your Honor, briefly, it's a motion in limine. I'm not alleging any constitutional rights violation. It's not a motion to suppress. And I'm assuming we're talking about the motion in limine to exclude all electronic and social media evidence.
Yes, that's what Joe Norman was talking about.
For which the Tennessee rules of evidence have not been satisfied. If they're satisfied, it comes in. If it's authenticated, it comes in. If it's not hearsay, it comes in. And I find it interesting that General Norman points out to particular sites, but she fails, and Your Honor may have been present when the Honorable Penny White gave a discussion on this topic.
Actually, I wasn't, because I had shoulder surgery and I missed that particular conference, because in reading your motion, I thought back about that, because otherwise I would have been there, because I admire Professor White and her presentations. I've sat through several of them, and she's very good, and I wish I had been there. However, I'll say afterwards.
And Your Honor, please, so in that, and we cite that this is a novel issue, we're not saying in this particular motion, there's a motion, another motion in limine, but in this particular motion, all we are suggesting is that the Tennessee rules of evidence be followed as it relates to any electronic digital media, and that the hearsay rules be abided by. That's what we're saying in this motion. We didn't file a motion to suppress a video. We didn't file a motion to suppress images. We're just saying, be mindful, Your Honor, please, that until the rules of evidence are satisfied, that they can be authenticated, and that it's not hearsay and it's admissible, that this honorable court then allow that information to come in as evidence. That's what we're saying. That's a motion in limine. And that's why we're here. And it kind of goes along with my second motion in limine to limit and exclude particular testimony of Detective Gish. And again, Judge, this is not a motion to suppress. It is what it says it is. It's a motion in limine, and we're asking that the Tennessee rules of evidence be complied with, and we're asking that any hearsay be not allowed as testimony. And that's what we're asking as it relates. And I can get into, I don't have to do it long, but it kind of ties into my other motion. If the court would like for me to address those things, itemize them out for the court of what I'm specifically referring to.
I don't think that's really necessary, quite honestly. The reason being is I have done a number of seminars on this very issue about this kind of evidence, and if the rules are complied with, if the court is satisfied that the evidence is properly before the court, then it will be admitted. All right.
Understand. Very well. That's all we're asking for.
All right.
Can we take up my second motion?
Yes.
Your Honor, please, we had filed a second motion in limine to limit and exclude the testimony of Detective Gish, and I appreciate Your Honor hearing me, and I'll try to spell this out just the best I can. One of the things we speak about in this motion is to exclude what I refer to as surplus comments. Detective Gish does a fabulous job, and everyone's thankful for the services that he provides. However, based on his prior testimony, there are some statements that we believe is vouching for the credibility of other witnesses. For example, when he refers, I think, to Officer Shreve, he says he's a seasoned officer, seasoned detective. We think that that's surplus commentary. He's vouching for his credibility and that not be admitted. He speaks of being assigned 7 detectives out in California from their major crimes unit. We ask that type of testimony be admitted. It's irrelevant that he was assigned 7 and they come from the major crimes division. I think it's completely okay for him to say, God help. I think Detective Mayo said they assigned 2 individuals to help him, and that's okay. But to elaborate further and add that surplus commentary, we think in essence that it would be vouching for the credibility of other individuals, and that's just not proper and necessary. So that's the first thing, Judge. That's one that we're asking this court to just instruct Detective Gish to limit those surplus comments if this court finds that well taken. The second thing, Judge, we ask that Mr. Detective Gish not be allowed to identify particular areas of the alleged victim unless the alleged victim is portrayed in whole. And what I mean by that is if he's identified the alleged victim in this case and there's a photograph of the alleged victim, he can say that's the alleged victim. But if there is a photograph of a particular area where the alleged victim, unless he's familiar with that particular area of the victim, that he be not allowed to identify that portion unless through his investigation the alleged victim has told him that's me and that's my particular private part of the body. I don't think he has the knowledge of a particular body part, Judge. And I think absent that he'd not be able to identify unless it's in full. And I think that's warranted. That's the second thing. The third thing, Judge, is Mr. Detective Gish will talk about in his prior testimony, he talks about shirts being pulled up, he talks about underwear being taken off, and he talks about these, and that is not shown anywhere in any of the videos. There may be some still images with the shirt pulled up, and I think it's appropriate for Detective Gish to say that's the alleged victim and her shirt's up. But to hint that someone pulled her shirt off, or to suggest that her, I think he uses the word panties at some point in time, has been taken off, unless there is something based on those videos or those pictures that indicate that someone take them off, we ask that he not be allowed to testify as to that part, Judge. Also, Your Honor, please, the fourth thing, he speaks about handprints and physical appearances of the body. There's been absolutely no testing whatsoever. There's been absolutely no proof presented up to this point that the alleged victim was assaulted in a mannerism of being slapped, punched, drugged, any of that. And so we're asking that the court instruct Detective Gish not to comment on, you can say that that's the alleged victim, her buttocks appears red, but to suggest that that's a handprint, unless there's some type of scientific reliable evidence to suggest that that's a handprint, we ask that be excluded. And this is all laid out in my motion. Judge, the fifth thing that Detective Gish spoke about, and the court entertained an objection briefly previously. Detective Gish at prior testimony spoke about what Joey Quinzio said to him. That's hearsay. And the state says, well, that's a co-conspirator statement. Well, it's not a co-conspirator statement. State v. Henry suggests it's not a co-conspirator statement. A co-conspirator statement is a statement made in furtherance of the conspiracy, during the conspiracy. And State v. Henry is very clear. If you have a conspiracy to rob somebody, and when that conspiracy, that object of the conspiracy has excluded, unless there's a separate conspiracy proven, and this court rules by preponderance of the evidence that there was in fact a conspiracy, then that statement is not a statement made in furtherance of that conspiracy. So Quincy O can say what he says when he gets on the witness stand, but Detective Gish should not be allowed, and if the court, what is required on statements is that this court conduct an out-of-jury hearing as to this statement and decide by preponderance of an evidence that there was in fact a conspiracy, that the statement was made during and or in furtherance of that object of that conspiracy by preponderance of the evidence. That's not been done in this case, not in this trial at this point in time. So we would just ask that any statements made to him by Mr. Quincy O or anyone else not be admitted. They're hearsay, and there's not a hearsay exception as it relates to that particular portion. Your Honor, please, part of our motion is to exclude Detective Gish from narrating or commenting on text messages. As I pointed out, Detective Gish did a fabulous job. He's good at what he does. Detective Gish is a digital forensic scientist, I believe is the way he puts it. He extracts data. That's what he does. He hooks the device up, he pulls it. There are some things you have to do, and he's very blessed with the talents to do those things, but he extracts data. And it's littered with State v. Brown, State v. Chapman, State v. Cook, State v. Thorpe. Those reports can be admitted for identification purpose only, but those text messages are a statement. They're a statement made by someone. A statement that Detective Gish was not part of the conversation, and in fact Detective Gish was not anywhere around in that conversation. And it's a statement just like any other statement, and we can liken it to having Miss Martell talk about the statement that maybe Mr. Vandenburg gave to G.L. Black. She can't. This is no different. Just because he extracted data does not give him he's not blessed with the opportunity to read those statements. That will come from the alleged victim in this case. That will come from Mr. McKenzie. If it's a statement that Mr. Vandenburg has made, that's a different story, we understand, but this is a statement. It's a statement. It's not treated any different because it's typed on an Apple iPhone or a Samsung Galaxy. It's a statement, and we're entitled to everything that exists when it comes to the rights to confront our witnesses, for them to be authenticated. And the cases that I spell out talk about that they have to be authenticated. G.L. Black has to identify that a statement was made. Detective Mayo has to identify that a statement was made and that statement was given to them. And we're not saying that they can't ultimately come in, but Detective Gish is not the individual that they come in through. He can present them to Your Honor. He can present the reports, and then if the state wants a portion of a text message read, they can ask the alleged victim, you had a conversation with XYZ, yes, and you received text message from XYZ, yes, and did you receive this text message? Yes. And when they read that text message, it's admitted, but to allow those text messages to be read to this jury, those statements made out of court, made by someone other than the declarant, the person giving the testimony, should not be allowed to come from Detective Gish. They talk about State v. Cook, particularly talk about text message, and they talk about if there is some form of shorthand. I always have trouble with this. My wife uses shorthands in text messages. Sometimes I don't know what they mean, but if there's certain words that people use and it's just not the standard English that individuals use in text messages, Cook has suggested that a layperson that was part of that conversation could decipher to the jury what that may mean if the jury couldn't figure it out on its own. The jury can figure out what they say. They're in standard English testimony. And the courts also suggest that that should not come in from an expert, but from a layperson, not an expert in deciphering text messages. So we enjoy the right of confrontation. If we didn't enjoy the right of confrontation, a constitutional right, we enjoy that right very well. If Detective Gish gets up there and talks about something that someone else says in the text message and that person doesn't get on the stand, that statement, that message has come in, and we have not been given our right to confront that witnesses. It's hearsay, and it can't be authenticated through Detective Gish. And Your Honor, please, I'm not saying these ultimately can't come in. That's not what I'm saying.
I know, I heard you twice say.
Okay, so that is our motion, and we respectfully request that Detective Gish be limited as to his testimony, and specifically that any text messages that are not the text messages of Mr. Vandenburg not be narrated or read unless it's by the person that was the sender. State v. Chapman uses this language, the sender or the receiver of the statement. Thank you, Your Honor.
All right, Mr. Jones.
I guess I'll try to start at the beginning. Mr. Boland was arguing several things. As it relates to Detective Gish testifying to any statements of Joseph Quinzio, they are objecting, saying that it has to be statements of a co-conspirator during the course of a conspiracy, which we do agree that that is the law. However, it is during the course of the conspiracy of the destruction of evidence, including videos and messages. And those would be the statements that Detective Gish would be testifying to, or statements related to that conspiracy. Your Honor has heard testimony at multiple pretrial hearings, as well as previous trials, where I believe that Your Honor can determine that there was a conspiracy to delete videos and evidence in this case, as well as devices in this case. They go on to then say that Detective Gish, which I'm going to kind of skip to their third argument because it's in the same topic, that Detective Gish should not be able to read text messages. And I know Mr. Boland references State v. Brown, State v. Chapman. I don't see any reference to those cases in the motions that he filed. So we weren't given any notice that he was going to be arguing those cases so that I could review them and review the facts of them. However, based on the motions that he did file and the law provided, I would imagine that they don't involve this exact scenario again. This is not a witness that is reading someone else's text messages. Detective Gish is an expert in the forensic analysis of computers and cell phones. He is testifying as an expert witness. His testimony is wholly different than that of someone involved in the conversation. He absolutely can testify and introduce evidence of the digital evidence that he recovered from the devices. Obviously, Detective Gish has his analysis and work on this case is extensive, and he can go into great detail of how he was able to determine exactly which messages came from which device and how he was able to multiple times over confirm from different devices who's sending messages at what times, et cetera, et cetera.
I know you can, because I've heard him testify numerous times to that.
The messages that the state will be proffering are messages between Mr. Vandenburg and another person. And there are a couple of messages that he is not a person in the messages, but it is a co-conspirator in furtherance of the conspiracy to destroy the evidence and cover up the crime. Which again, there are just a few messages that are between one of his co-defendants and someone else, but the majority of the messages are between Mr. Vandenburg and someone else. However, that's not really the issue, because it's Detective Gish testifying as an expert witness, which is completely different because he extracted this data in his forensic analysis. Going back to their second issue, they said that, I believe, they were talking about him being able to narrate, that he can't narrate and describe what is shown in an image, which is somewhat odd, as they defense counsel just asked Felicia Evans to describe what she saw in a photograph that she did not take and she's never seen before. And now somehow they want to say that Detective Gish, who has seen the photographs and the videos and actually has seen surveillance video and basically the entire case file, that he should not be able to narrate that. That is not what the law says. He has viewed this evidence. His testimony, he can absolutely give testimony as what it appears to be to him. It appears to him, and he can describe what he sees in that image that he recovered. If the defense counsel wants to cross-examine him about it, they absolutely can do that, but he should be able to testify to what he sees in those images, and there is absolutely no law that supports that a detective and an expert in computer forensic analysis and digital analysis would not be able to testify to what is shown in the images that he recovered through that expert forensic analysis of the device.
Okay. Well, any further response? Because you'll know.
Just briefly, I do want to point out to the board, we're not saying that Detective Gish...
Yeah, go around to a microphone.
Detective Gish is an expert in digital computer forensics analysis. Just because you're an expert does not trump Mr. Vandenburg's right to confront and cross-examine anyone that has given a statement or witness against him. These are statements. They're text messages. If they are Mr. Vandenburg's statement, then there's a hearsay exception to that statement. If there is no hearsay exception, expert witness is not a hearsay exception. And he's an expert witness as to digital forensics analysis. We're not suggesting the text messages can't come in. He can introduce his report that he extracted. He absolutely can introduce that. And it can be for identification purposes only. When that declarant, when that individual who sent or received the statement, the text messages, says that's the statement I received, it's then authenticated, it's then not hearsay. That individual can discuss that, and we have our right to confront. Detective Gish wasn't there, Detective Gish doesn't know the context. Respectfully, all Detective Gish knows is what was extracted from the devices that he investigated. And so that's my first response. Second response is we're talking about a conspiracy to cover up. First, the state's going to have to put on proof. There's going to have to be proof that there was a conspiracy to cover up, and that's 2 or more people identified that agreed to do a certain act. They would have to put on that proof, and this court would have to find by preponderance of the evidence that that conspiracy existed, and then as a result of that conspiracy, there were statements made in the course of or during the conspiracy. Thank you, Your Honor.
All right. Well, if I can try to respond to all of this. Well, first of all, with respect to Detective Gish's testimony with regard to things that you say he expands upon, or however you phrased it, making commentary, etc., of course, or as you say, exaggerating comments relating to the case. Well, you know, any of those issues that come up, of course, you have the right to object, and then I can rule on it as it comes up. But you know, I find it difficult to try to say, well, I don't want you to say this, and I don't want you to say that, and I don't want you to say, you know, that's a little difficult to do. But you can object if you believe that there are statements being made or testimony being made by Detective Gish that are in fact objectionable. Next thing, with regard to Mr. Quinzio, I think we have previously had a hearing on this very matter. I'm not sure whether you were involved in it or not. I can't, because there have been so many attorneys, I can't keep up with who brought up this issue at which time. I know that it was raised, and I think that it was particularly with regard to whatever statements Mr. Quinzio made, and I think that it was shown that this was a part of a conspiracy to cover up get rid of evidence in this particular case. So that issue, I believe, has been dealt with. And as to what statements he may have made, we'll just cross that bridge when we get to it. with respect to text messages, well, let me go to the images. You know, witnesses can testify as to how something appears to them. Again, if it's something that is objectionable, then of course you would raise that objection. But if Detective Gish says that it appears to me this, then that's allowable unless it's something that's just outside of the realm of any reasonable person's belief. So he can testify in that regard. Again, you can object to whatever may come up. Now, with respect to text messages and him testifying as an expert, there's a kind of a thin line that goes there. I know you have a right to confront witnesses, confront statements, but it just depends on the context. And again, that is something that I will have to deal with, you will have to deal with as it arises in this particular trial. I can't put it any other way because I can't really just speculate about what questions are going to be asked, what answers are going to be given. It just remains to be seen. Okay? Now, and one other thing I wanted to mention is with respect to body parts. You said that Detective Gish cannot identify body parts. Now, I think all of us in here can identify body parts. So I don't think that's really an issue. If he believes that a buttocks is being shown, he can testify that a buttocks is being shown. You can't just say, well, that's the alleged victim. Okay? So I don't know what else I could say with regard to the issues that have been raised here. We'll just kind of take it as it develops. I can say this: we will take a 10-minute break and then we'll get started right after the 10-minute break. Okay?
Please, just one thing that didn't touch on, Judge.
All right.
Respectfully, thank you. One of the things that I did speak about that the court didn't address just then in that oral order was the references of Detective Gish talking about someone being slapped and those type things. So the court may need to elaborate on that. There's nothing been put into the evidence as far as demonstrate that. There's absolutely no testing procedures been done.
Well, again, if something like I kind of touched upon it, but not specifically. If something like that comes up, of course you would object to it. Just because someone has what appears to be a bruise does not necessarily mean that that person had been slapped. Understood. But again, I can't speculate as to what Detective Gish is going to say. All right? All right, we'll take a 10-minute recess.
All right. We'll be on a 10-minute recess.
Let them know.
Yes, sir.